Hi, I'm Jacob Butler. I'm one of the attorneys at Spellon Law. I primarily focus my practice on workers' compensation cases and personal injury cases. One of the first things you need to do if you're injured on the job is you need to tell your supervisor or your employer so they can file a first report of injury with the Alabama Department of Labor. They'll also be able to direct your medical care. Depending on the severity and the type of injury you have will depend on where they send you for medical treatment. You may not be able to report your injury because you were so severely injured. In that case, I suspect one of your coworkers will have informed your employer or your supervisor. Your employer is not allowed to take any adverse employment action against you as a result of you filing for workers' compensation benefits. That includes changing you to a less favorable shift. Say you were working day shift, they can't move you to night shift in retaliation. They can't decrease your pay, they can't cut your overtime, they can't force you to use sick days instead of work comp days. They can't fire you. All of these things where I'm saying they can't do it, what I mean is they're not allowed to do it. If they do it, it creates an additional claim called retaliatory discharge or constructive retaliatory discharge, and we can handle that case for you as well. The amount of compensation available to an injured worker depends largely on the type of injury they had, the severity of it, the permanency of it, how much they were making at the time of the accident, type of job they had, and any permanent restrictions they have. At some point, the doctor is going to say, that's as good as you're ever going to be. You're not going to be 100%, you're not going to be back to normal, but the doctor's going to say that's all we can do for you. This is as good as you're going to get. At that point, they'll assign an impairment rating and place you at maximum medical improvement.
A workers' compensation third-party case involves a situation where, yes, you were injured on the job, but your injury was the result of something that was completely unrelated to your employer or any liability of your employer. An example would be if you work at a machine shop and the machine that you're working on explodes on you. Well, the manufacturer of that machine may not have put the proper safeguards in place. A safeguard may have been removed at some point that could have prevented this injury. All those types of situations would arise and give warrant to looking into a third-party lawsuit on your case. If we're able to successfully go after the manufacturer of the machine that you're working on that caused that injury, your employer would be entitled to receive part of the compensation that they paid you back in what's called subrogation. But it would still be beneficial to look at this because you would be outside of the provision of workers' compensation that greatly limits you under the law. Whereas if you go after the manufacturer of this machine that actually caused the harm, you could be entitled to a whole lot more money. Historically speaking, workers' compensation is a statutorial makeup, pretty much as a trade-off where it's called a faultless-based recovery system. So in workers' comp, it doesn't matter if you're at fault for your injury or not. If it was a regular car wreck case or regular liability case, if you contributed to your own fault or your own accident, you wouldn't be entitled to recover anything under Alabama law. But in workers' comp, you can completely be responsible for your accident as long as you were on the job doing your job at the time of the accident.